May be seated. Thank you.
So, just for the record, I did make the change to the instructions that we discussed earlier about the date with regard to what the probation office knew. I did not make the change requested by the state that I had reserved ruling on. I will say I think the law is quite confusing in this area with regard to what the Supreme Court's Lane case and the Second Circuit's Garcia case mean together, as other courts have noted. But I thought leaving it in was what made the most sense in trying to analyze how those cases fit together. So, anything else?
Yes, Your Honor.
Mm-hmm.
Page 10.
Okay, it's a little late to raise new ones, but go ahead.
Page 10,
Yep.
items 5 through 8.
Right.
I say that basically we need to, let's start off with 5, that he requested reasonable accommodation from the probation officers. That's fine. Then we go to 6, that the probation officer could have accommodated the request.
Mm-hmm.
I think there should be a clarification there that the probation officer was mandated to accommodate the request if blah, 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 okay?
I don't know what you mean.
Well, in other words, if I was saying, provide me a limousine to come to my house and pick me up and bring me downstairs, down to their office.
And a couple of martinis while you're at it.
Exactly, okay? As opposed to that if the officer didn't basically want to come up to my house, that basically the officer could turn around and say, I'm not going to do that because, as the testimony said, they weren't field officers or there wasn't a field officer available or something like that.
Okay, I don't really understand your point, because what I'm saying here is they just have to find it was possible. In other words.
But it doesn't say anything about mandatory. In other words,
I don't think there is anything mandatory.
Under the ADA it is.
Only, I don't understand what you're referring to.
I'm saying that it's not optional in this case for a probation officer to decide as an option in the minds of the officer that basically they can just disregard it because they don't
I think that's what this says, that if it's reasonable and they could have done
But
it.
that part, 6, 7, and 8 seems to be a little bit clear. Like in other words, as an example, the best one is 8, that the probation officer did not offer a returnable, reasonable accommodation which the disabled person was capable of doing.
Well, then it wouldn't be reasonable.
But there again, that's what I'm saying.
Okay, but I mean, I think the jury can figure
in the
that
minds
out.
of the juror, they're gonna say what is reasonable and what isn't.
Okay, well, under the law, reasonable is a term we use a lot, and generally speaking, that is a decision for jurors to decide.
But maybe
not
what
for
you ought to do is
humans.
read Black's Law Dictionary of reasonable.
I don't think they need to. I think most people can figure it out. Okay, so I'm denying your request on
And
these.
they basically said it, that the probation officer refused to do so, or did not do so in a timely manner. Again, it basically doesn't include something to the effect that I had the DMV documentation, and basically, not only the disputed doctor, but Dr. Coxon, which again, can't testify to, that I can't admit that document. So they got 2 written things that they had, and basically, even with that documentation, that wasn't good enough for them.
Okay, and Mr. Nolen, you can argue
Okay.
that they were not reasonable, that you gave them a reasonable
Okay.
offer, and they were unreasonable in denying it.
I'm just pointing out what I think.
Okay, I understand what you're saying, but I don't think that there is an error here in terms of what the law requires. Anything else?
No.
Okay, so I am ready then. We have copies made. Oh, sorry.
Oh,
No, go ahead.
I just wanted to raise the issue. I have a chart which is a compilation from the evidence of times Mr. Nolen was asked to visit the probation office. And the times that he chose to visit the probation office and the times that he
I can't see that, I definitely can't read that far.
Let him take a look at it. What is it that you would like to do with it?
I would like to use it as a demonstrative aid during the closing.
Okay, and what that means, Mr. Nolan, is just that he'd like to hold it up when he's making his closing argument. Any reason you object to that? It would not go to the jury room as an exhibit.
What, I don't understand, a can't pick up permit, he's in transit? What is this?
There's a note that indicates that on August 8th, you told a probation official that you couldn't pick up your travel permit because you were in transit.
Oh. But that wasn't, that didn't come out in any of the testimony.
As long as it's in the exhibit that's in evidence, he can refer to it, and that
Okay.
case note is in evidence. I'm assuming you're talking about the case note.
Yes.
And what is this missed home visit 823?
You missed, I'll explain it. To the jury, the point is you had a scheduled appointment on 8/22, which you missed, and a home visit was conducted on 8/23.
Well, I don't read that this way. It looks like missed home visit, like I wasn't home.
Okay, I could X out missed if that clarifies.
Missed office,
I could,
You guys work it out.
sure. What would you like it to say, Mr. Zoll?
I still don't understand. I missed an office visit,
Right,
and then she came to my home.
correct.
So why don't you put that, missed office visit?
Visited the plaintiff at home.
Is that good? I know it won't be tight, but
Let's see if he writes like a doctor.
I hope not. But with that correction, you're okay with him using it? Okay. Mr. Groff, did you have any other issues?
No, okay.
All right. Mr. Nolan, anything else? All right, so the plan, just to be clear, we're bringing the jury up. Mr. Nolan goes first with his closing. Mr. Groff goes second. If you want to respond briefly with just a couple minutes when he's done, you may, and then I read my legal instructions.
So I get last place, and
You do.
And are you going to have a stopwatch to give me exactly 1 minute and 30 seconds or what?
Well, let's talk about that. How long do you think your initial argument will be? 10 minutes, something like that?
Probably close to 30.
Okay, that, I think given the hour, that's going to be hard for the jury.
And again, that goes to basically my request to have this thing continue. My
How much
assistant over
time?
here has 2 kids.
All right, hold on. How much time would you think yours will take, Mr. Groff?
Certainly, we can have 10 minutes of planning for me.
How about if you try to do 20, Mr.
I don't
Nolan?
think I can.
All right.
I've got an outline over here, and there's no way I can do it in 20. Maybe 25 if I talk fast.
All right, let's shoot for that. Their dinner isn't here yet, is it?
It's anticipated, but
Yeah, it's not here. Okay, I'll have to wait. So let's bring them up and go. Oh, Lori, I walked off with 2 exhibits. Do you have all the others? Have you checked? Okay.
I think it's that. A who?
It's a hair hair.
Oh, a head here. You got close to the head here. She's talking about hair.
I went like that, and it's like, what the heck?
You're trying to make
If
a...
it's that long, it's definitely yours. No one else in the courtroom goes on here like that.
Isn't her hair gorgeous over
It
here?
is very pretty. I noticed that earlier.
You trying to make a hydrometer? Did you ever do that in elementary or high school, make a hydrometer with human hair?
I don't think I did. I wasn't a very good science student. That's why I
They-
became a judge.
They basically used to take, I remember this one class, and we did a lot of weather because the science instructor, teacher was into weather. And he said you can make a hydrometer, you know, that deals with
Moisture.
humidity, moisture in the air, by taking a long hair like that and somehow tying it on 2 ends and make some kind of scale. that the
Sounds
human
reasonable.
hair basically expands and contracts depending upon the humidity.
Sounds like a good kid project.
Hold for each other. All right. You can be seated. Thank you.
Welcome back, everyone. Sorry about that long break. There's sort of some complicated legal issues in this case, so it took longer than it sometimes does. But we're now going to the closing arguments, and we'll start with Mr. Nolen. Mr. Nolen?
Thank you, ladies and gentlemen, for putting up with 2 days' worth of testimony and court proceedings. I really appreciate it. As I said in the very beginning of my charge, this case deals with 2 timelines in terms of the probation issues themselves. Number one, I don't think that in your minds that there's any question that from the beginning of this action, straight through today, that I'm a disabled person as that term is defined in both federal and state laws. That basically, I asked for reasonable accommodations from all the different state officials, that they basically gave me the roll runaround. And basically, starting with probation officials. The first witness, Ms. Pratt, basically testified, I was a good little boy, I basically didn't violate any of the provisions. She testified that I requested reasonable accommodation. There's the only question in terms of whether or not, as to when and who got the DMV request for the placard. There's no question in terms of the document as to when DMV received it. No question that basically the department could have gone to them to authenticate that they got it. There's no question in terms that the doctor, there's no allegations that I forged the document, that basically the document didn't speak for itself. The document states that basically I can't walk more than 200 feet without stopping. You've heard different measurements. Basically, you have to say, okay, they're admitting there are these distances. They're admitting, as an example, at the Barry office, the sign that says, do not sit on this wall. Anytime. It also says don't trespass, blah, blah, blah. That's not an issue. The issue is basically you cannot sit on this wall. They also testified that that is vigorously enforced, or pretty much enforced as a major thing. Of course, being on probation, I didn't want to basically violate any rules, regulations, violations, anything. I didn't want to give them the even chance to basically say, hey, you did this, you did that. You basically saw that. In terms of the doorway, they've said that when I had a driver's license, which basically was valid in the beginning, but wasn't later on, that I could park in the rear of the building and have a handicapped accessible space. Directly in the front of that space is what the corrections officers, probation officers said were employee-only doors. The pictures speak for themselves. The testimony of the officers speak for themselves. It was an employee door. I basically asked all the different people, give me a reasonable accommodation, let me go through this door. The last witness here testified that supposedly I should have been able to go through. You've got to weigh the evidence. A probation officer, both of them testified that is their building. That is their building that they primarily have as an office.
This guy that testified the last basically says he's all over the place. He doesn't necessarily know a lot about this building or any one particular building. He's a general state manager, if you want to call it, of facilities. He also says that basically he doesn't know anything about the intercom system. He can't reasonably say where basically this intercom is, where the officers, security officers, was my testimony that was a Washington County Sheriff. He didn't know. And there's no testimony about it. I said that it was a Washington County Sheriff. I also said that there were numerous people that were named in this action, that for procedural or other grounds, the only people or the only entities that are left that you have to consider is the state and its agencies. So we can't deal with those people. You will have, as the judge said, a statement made by the chief administrative judge because she preferred not to come here. You've got to say to yourself, here is basically the state, and it's got its agencies, its bureaucracy, including the judiciary. And in your mind, you've got to say, you've got access to court areas that basically are at the Barry Courthouse that I'm alleging that I had problems physically getting into, that I basically had problems with probation and parole, which is part of the overall court system, and that I made reasonable requests. And then we get into the travel permits. I said, why can't you basically fax me this thing? I got a fax machine. Why can't you basically send it to me email? I'll print it, I'll send it right back to you. I don't think there's anybody here in today's technology, again, common sense and common everyday things. They're talking about forgeries. There's no allegations of forgery. They said if you're a pedophile or sex maniac or whatever, they've got some other stuff you got to carry with you. Doesn't apply to me. There's no allegations that basically they said that I had that level. In fact, they said that I was a high level, and the first corrections officer testified I was downgraded. She also said that basically I only had to turn around and appear. Part of her testimony was every 2 weeks, then she said 3 weeks. That's a discrepancy. But all in all, they said she would work with me, fine and dandy. Next thing happens, you got a new probation officer that's assigned. Suddenly, this probation officer and her supervisor, this woman didn't testify because she's no longer a employee, as the state says. Her supervisor was there, supervised everything. He said, damn it, you got to get down here. If you don't get down here today, we're going to violate you. You're uncooperative. Look at the document that basically was filed, that is into evidence, that they make these allegations. That I basically had some kind of contact with the alleged victim in the postal case. They testified basically there wasn't any contact. They testified that basically I didn't have mental health treatment. Again, I had Dr. Valencourt that was here that testified, a licensed psychologist, that basically not only did I turn around and do it and go to him, but I basically turned around and did it voluntarily. Me. Even though I had problems finding this guy, I found him. And I arranged, and as he says, I've been continuously with him. Then we basically go to the fact that the first witness, corrections officer, says, well, you know, I thought you needed it, but I didn't make it mandatory. I didn't say you had to do it. You haven't heard a single testimony, even the supervisor can't come up and say, I have a piece of paper that basically says you have to do this. I use common sense. If somebody's going to go to the extent of violating somebody in probation, and I'm sure you guys through common knowledge, know that there are people out there that miss curfew, they turn around and they're intoxicated. In some cases, they even get arrested for DUI. Think about basically what you've heard during this untried trial. Why should they turn around and basically violate me? Going to my damages, I basically had to fight them in the Vermont Supreme Court. Not just the direct appeal, not just basically a PCR challenging it, ineffectual assistance of counsel, which again goes to the inability to get to the law library. But basically, when they decided that they were going to lie and they were going to turn around and make these false allegations that basically I somehow did something that caused them to, whatever you want to call the term, there's different terms that they use, that they would punish me by knocking off me from probation. I didn't take that. I basically want to have as clean as a record as I could. So I basically turned around and said to them, I'm going to challenge you. I had to go to the state's attorney in order to file papers in court. That I had to go to the state's attorney. Look at the document. It's unsworn, meaning, as I testified, and you can see the document yourself, coincidentally, if I could prove, or a law enforcement agency would want to try to bring charges, because it wasn't sworn to under the penalties of perjury, they basically couldn't be punished for the mistake. So they said, oh, this guy's giving us a lot of problems. He's do this, that. We're going to sock it to him. The fact that basically I said to them, why don't you turn around? You need to see me. I live 1.2 miles on an uphill coming home and a downhill going to their office. 1.2 miles. They don't dispute. They say 1 to 2 miles. Picture yourself with a quarter-size thing on your big toe and basically try to walk 1.2 miles. I don't think anybody here would try it and punish themselves. Never mind basically saying, hey, you got to turn around and get there. And I broke my back, sort of, to basically find transportation. I got down there a little late, and I showed them by foot. That wasn't good enough. Then we basically go to all these buildings. 109 State Street. There's a ramp that's straight down. They said it's straight, but it's a little bit too steep. Then we go across the street. You've heard testimony that the ramps are too long. Think about what you would do. Would you rather have a straight thing that's a little bit too steep? Or would you rather basically go long distance? The same thing goes with the parking space that's there. Again, the pictures, the testimony, all say there are 3 spaces. They had all of a sudden, for whatever reason, again, you could draw your own conclusions. They take these 3 spaces with this a little bit steeper than normal, a couple of degrees was testimony difference. They say, no, you can't use that. We're basically going to allocate these to the treasurer. The treasurer basically said the testimony was that he wasn't disabled. There was no disabled person in the treasurer's office. Think, why would basically they not keep these spaces? They talk about security. Well, think about it. If you wanted to blow up that building, treasurer people aren't there all the time. So all I got to do is they did wherever, load my car with explosives, pull my car in, up goes the building. Certainly can't be security. Got to be an excuse. Draw your own conclusions. Then we talk about the bureaucracy. This man here turns around and says, hey, I'm in charge of all the state facilities in the entire state. I'm the guy that basically, if you've got a problem with this, I'm the guy to go to. From 2011, when this case was filed, and of course, before this case was filed, I did everything that I could possibly think of to get some of these things changed. they basically turned around and basically said, we'll not do anything. As soon as basically this case comes to court, suddenly this last guy gets notified. Use your own judgment. Guy that's in charge of all the facilities, you file a lawsuit, and it takes 3 years for the guy that's in charge of all the buildings in the state to do something. Use common sense. Then we basically go to expense. Do you think it would cost the state anything to basically send something to me by email? Email's free. Fax is free. So why didn't they do it? They basically can turn around and say, we're going to open up the door at the Barry Courthouse. When people, like this guy testifies, he says that basically you have a problem and with an ambulatory issue, you want to go through that door, go up there, ring the doorbell. He testified there's signs that prohibit it. My own testimony and the testimony of the corrections officers know how much is going to cost the state to allow somebody that door. How much trouble in terms of lack of security or whatever when you have a straight version from one side of the building to the other. You can see straight through. The pictures again demonstrate that. You've got multiple officers in the lobby at the courthouse. I'm the officer. The door's where this lady, juror, in front of me is. In terms of direct line. I can see the person at the door. If I see somebody at the door that's in a wheelchair or one of those walkers or even a cane, unless the guy basically or gal is holding some kind of gun or looks dangerous or whatever, I'm not going to think twice. The testimony, my testimony and others, is I'm a litigious guy. I'm guilty of that. I'm an activist. I'm well known in this area. All these people except for this gentleman and the ADA coordinator or whatever, they all know me. They know me on site. The same thing goes with these security personnel. I'm not a violent man. I don't have any violent history. So what's the big deal? And most of the time when I was trying to access these buildings, it was basically off hours. I wouldn't come in when there's a lineup. Sometimes you go to New York City or Boston to these courts, and you got to line out the door. They didn't say anything about that. They made absolutely nothing that says cost-wise, security-wise, or anything that they couldn't do each of these things. Then we go to a library. They testified that there is no table that basically a person with a wheelchair can get on. I don't know how much of you guys do stuff on a computer, but if I got my computer over here and I've got to sit this way, picture how you basically can turn around and do it. I testified that I have litigation. I testified that basically I had court cases that got dismissed because I couldn't do legal research. Think of this case themselves. Just before the judge gave me permission to give this summary, she said, this is a complex case. I didn't have just one case. I didn't have two cases. I had dozens. And the testimony was that basically it was even interstate in New Hampshire and other states. Again, I'm a litigator. I'm not an attorney, but I have a right to litigate. What you've got to think of is if I wasn't disabled and I basically could do these things, and then suddenly the access to programs, the library, corrections, people don't think of corrections and probation as a program. It technically is, legally is. All these different places basically comes under the ADA. And if I was limited strictly because of my disabilities, and I could give them ideas, and my idea was at 109 Straight Street, let me park up above. Give one of the spaces that the treasurer might not have. Give me a chance to basically go there when the treasurer isn't using all three spaces. They could have done that. There's a zillion and one things they could have done. They could have given me valet type situation. I call up, I'm downstairs, can you do me a favor? Let me off here and basically park my car. They didn't do that. Correction officials, the building, the library, none of them could come up with reasonable accommodations. I didn't want to waste your time, my time, the court's time, by giving all the different possibilities that would meet security, that would meet basically the supervision of me. They testified I was low level. They said they came to my house once. Think about all the people that you know, your neighbors, you read in the newspapers, you hear about these guys that basically arrested time and time again for DUI, drugs, all this different stuff. Not me. I don't do drugs. They admit that I don't do drugs. I don't do alcohol. I think I've had maybe 4 drinks in my entire life. I don't do alcohol. I actually, although it didn't come out, I basically have a problem with alcohol. The bottom line is, you've got to think, why would they do this? Well, the treasurer basically had Al LaPearl. He said he was in bad property. You're thinking, well, why would they pick on a guy like this? People remember the 1929 bank run, when people basically correctly thought the banks were going to fail. They turned around and they basically said, gee, I better get my money out of this bank. So they ran to the bank, but there wasn't enough money to pay all the deposits. History repeats itself. 2014 or 2011. Mr. LaPearl said, I'm one of these guys, again an activist, that basically I started to say that the state isn't doing enough to return money to the rightful owners. You steal something, you expect the rightful owners to get your money. You basically are the treasurer. You got a statute that says under certain conditions, dormant bank account or whatever, you've got to...
Mr. Nolen, I hate to interrupt, but I don't think there was actually any evidence presented on this point, so you can't really be arguing.
Well, there was testimony by LaPearl that I'm getting people to file claims for abandoned property.
I think that's about as far as it went, though, so let's move
on. Okay. You've got to turn around and basically say, why? Is it because I'm black, I'm Hispanic? No, I'm a Caucasian. We're all Caucasians, as far as I know in here. Anyway, so it can't be that. So what would motivate these probation officials to do what they did and to not do what they should have been doing? Why did they have these strange policies that a reasonable person would say, what is the purpose of it? And if you, using your normal intelligence, can say that there's basically no basis for it, then again it goes to the issue of reasonableness. And I think that if you look at the distances involved, the fact that there are many people going in and out of these buildings and basically seeing all these kinds of problems, that there's no way that if you're a state employee and you see a crater in the ground that you're not going to report it. And if you don't, if you see it and you don't, whose fault is that? Is that my fault? Is that any of your fault or private citizens or the state? No. If something happens in your house that basically somebody trips and falls in a crack in the pavement, it's your responsibility. You're liable as an owner. If you're a storekeeper, even though you're not the owner of the property, you're still responsible. The bottom line is, think, why would you allow these conditions? There's been testimony in terms of they had knowledge of all these obstructions. They admit that even recently, and they use the word cross heaves and all this other kind of stuff. So what? So you get a frost heave, you fix it. You put in some kind of filler. Everybody here, I'm sure, probably knows the wonderful craters that you got in the road. But when you're talking about the disabled, And basically, you got talking about somebody in a wheelchair. It's not that you just turn around and bend your rim or your suspension system or whatever. For a disabled person, it's pretty serious as to why somebody like me would be a pain in the you-know-what and complain. And the more I complained, they just said, we'll get around to it. Even the testimony of this last witness said, he knows stuff, it's been clear weather. Again, you tell me, why basically does it take so many of these days? They got all these workers all over the state. But when it comes to the disabled, and there are physical problems in terms of payment, sidewalk, and what have you, their answer is, well, we'll get around to it, we'll take care of it. You also heard testimony that the U.S. government told the state of Vermont, don't hold any hearings where federal public funds are there. You've got an even email from a state employee, although she didn't testify, that instructs people, don't hold hearings. And then they turn around and they say that, hey, you know, we sort of fixed it, but we didn't. But read that email carefully. It specifically says any other building that basically is what happened. And instead, as they basically testified, not only did they disregard it for other agencies other than HUD, they basically turned around and kept having hearings. Hearing after hearing after hearing. And the disabled...
Mr. Nolen, there was no evidence about that. I'm also going to point out that you've been going for half an hour, which is what you told me you needed, so if you could...
I have nothing further to say.
Are you sure?
Yes.
Okay. Mr. Rock?
Thank you, Judge. And thank you, ladies and gentlemen. I'm going to set up the computer. Thank you again. We appreciate the service you've given us. I agree with Mr. Nolen about one thing, and that's that this case can be decided based on common sense and reasonableness. Ask yourself, what's more reasonable and what makes more sense? That the federal government inform the states that some parking spots in this area with this approach didn't comply with the ADA.
Excuse me, Your Honor, I'm going to object. There wasn't any testimony in terms of the specific spots. He just said that...
There actually was, Mr. Nolen, overruled.
So that this spot was constructed to comply with the ADA, and that it was designed and built to comply with the ADA, or that these spots were randomly taken away as some sort of conspiracy related to the unclaimed property division. Which of those makes more sense? And with respect to the courthouse in Barry, what makes more sense to you, that for legitimate security concerns, that the state wanted to make sure that everyone was processed through security, or that if this was some unidentified discrimination against Mr. Nolen for no apparent reason? We think, frankly, that the answers to those questions are pretty obvious. And then, again, just apply your reasonableness to Mr. Nolen's claims regarding accommodations as well. He complains that he didn't have access to a library, but the evidence is undisputed that the parking lot complied with the ADA, that the library staff did research for him, did his research for him, that they sent him materials whenever he asked for them, that they offered to bring materials down to him in his car, and that they offered to physically assist him to get to the library. That doesn't sound like a denial of accommodations to me. And with respect to Mr. Nolen's claims regarding going to the probation office in Barry, I mean, ask yourself this. Is it reasonable that Mr. Nolen couldn't make it, his claims that he absolutely could not make it into the probation office? First, let's say this. The evidence will show you. This is a chart made up from admitted evidence in this case that during the 4 months that Mr. Nolen was on probation, he was asked by the probation officers to appear at the office a total of 6 times. He actually appeared without problem only twice, on 6/8 and on 7/25. On 6/22, he did appear. He originally missed the appointment, but then came in later when his probation officer called him. On this day, 8/22, he didn't show up for his appointment. The next day, his probation officer went to his house. On September 30th, when he had a new probation officer, he called up on his own and canceled his appointment and then refused to schedule a new one. Then he eventually was offered a new appointment the following Monday, told the supervisor that he wouldn't come, and then that he would come with the media, and then that he would sue everyone involved, and finally showed up after that. But in total, those are all the times that Mr. Nolen was asked to get into the probation office. Now, when Mr. Nolen wanted something for himself, like a travel permit, he was able to make it to the probation office on all of these occasions. 6 different occasions when Mr. Nolen wants something, suddenly he's able to get there. Now, and what was he there for? To get travel permits, to travel out of state. How is it that Mr. Nolen can travel out of state on 1, 2, 3 different occasions, but he can't make it a mile down the road in the town he lives in to the probation office? Does that make sense to you? Dr. Valancourt testified, Mr. Valancourt, the clinician, testified that he has had weekly appointments with Mr. Nolen since late August of 2011, and that Mr. Nolen has never missed one. Mr. Nolen lives in Barrie. Mr. Valancourt's office is in Bethel. How is it that Mr. Nolen can make a weekly appointment in Bethel, but he can't make a monthly appointment in the town that he lives in? Does that seem reasonable to you? Now, in order to be entitled to an accommodation, Mr. Nolen is obligated to prove that he's disabled. When he requested an accommodation from the probation department, they said, sure, give us some documentation of your disability, and we'd be glad to look into that. But he didn't do that. He said, I don't have a doctor, I can't do it, you go figure it out. Eventually he got a DMV form that was over 5.5 years old. And the state said, well, we need something more current. Now, when it did become apparent in October of 2011 that Mr. Nolen had some serious issues and went in for surgery, he was never asked to report there again. So does this sound to you like they're discriminating against him because of his disability, or that they're being accommodating to him? And although they denied his official ADA claim, they did give him accommodations. They said they would visit him at his house. They said every other meeting could be over the phone. They said they would meet him downstairs. Mr. Nolen likes to talk about the distance from the back parking lot to the front entrance, but he doesn't mention that for the bulk of this period of time, he had no driver's license. What is the relevance of the distance from the back parking lot to the front entrance when you're not driving a car? He could be dropped off in the front of the building, right next to the door. So we think that with respect to both the accessibility claims at both buildings, and let me say this, as to the accessibility claims, Mr. Nolen had 2 different disability advocacy groups go and do surveys of those buildings. The only issues that Mr. Nolen ever complained about that he wanted to park in the spots behind Governor Davis Drive, and that he wanted in Barry to be able to enter the restricted entrance. Both of his experts said that these spots, parking accessible spots in both places, were located on the shortest accessible route from accessible parking to accessible entrance, and that that was the standard, and that it was met at both buildings. Those are the experts that Mr. Nolen called. They both said that the law does not require that disabled people be given access to restricted entrances. What did his experts identify as violations? A 1/4 inch lip, a lip that exceeded the standard by a 1/4 of an inch. A lane striping that was 58 inches instead of 60 inches. A 2-inch curve caused by changes in the weather. Well, number one, Mr. Nolen never complained about any of those things, ever. Number two, there's absolutely no evidence in this case that any of those things ever prevented him from going where he wanted to. All he complained about, again, was that he wanted to park in the spots at the top of Governor Davis Ave, and that he wanted to enter in the restricted entrance to the Barry Courthouse. So we think that with respect to the accessibility claim and with respect to the accommodation claims, that Mr. Nolen has failed to prove his case, and that instead the evidence shows that the state acted appropriately. Thank you.
Because Mr. Nolen has the burden of proof, he gets another 5 minutes if he wants it.
They talk about transportation. Dr. Valancourt, as an example, testified that I was going through, he used the word GMTA, he didn't say Green Mountain Transit. Once I lost my driver's license, and I physically couldn't drive, to go from medical appointments to medical appointments, I basically had to and did use GMTA, Green Mountain Transit. That's what I did. But when it came to personal trips, I didn't have that option. And even if basically I could rely on that, I had to rely on GMTA's bus system. They have diversion. The only problem is, while they'll come close to my house and pick me up, they basically would drop me at a bus stop. Again, the testimony was that I could walk from that bus stop around.